Okay, so there is a parliamentary standing committee on personal laws, review of personal laws, and this is basically same as Uniform Civil Code, going in that direction. So they have asked for feedback of public by 1st of November, going by the 21 days limit. So the feedback has to be sent to this email ID, uh, and this is a very good opportunity for all citizens of India to send their feedback, because if you see this line, para 4, different stakeholders like concerned citizens. So it includes even a citizen like you and me. So I suggest that everybody who is concerned about reformation of the laws, uh, they send their feedback, and I have made my own points, uh, point summary in this kind of presentation. I will go very quickly over them, and I expect that people who are working in the area of men's rights, they should be aware of all these points. So put them in their own words, add your own points, remove what you don't like, but do send your feedback. So I think the first reform is for alimony laws, because under Indian laws, whether a woman, mostly it's the woman almost all the time who gets the alimony, and a very fat and obscene amount of alimony, even for a very short duration of marriage, whereas in other countries there is a duration of marriage as long as 10 years before you are eligible for alimony. Child support is a different thing. So this is something which needs to be brought as part of the laws, so that there is no misuse of the marriage as a way to get alimony after divorce. Now the other point is, what is the rationale for awarding a lifetime alimony, huge awards of alimony? Sometimes it is said that a woman, she has child or children, and she's taking care of them, so she can't work. But it's very commonly seen that even women without children, uh, they get a fat alimony, as per their liking, and otherwise they will not divorce, or they will keep the husband under pressure and his whole family through multiple cases, including criminal cases like IPC 498A and the other sections. So short marriages, again duration, no children, why huge alimony, or why alimony at all, if there is no fault. That brings to the third point, if there is no fault, or for example rather, if there is a fault, husband is able to prove cruelty or adultery by the wife, now why should she get a very high amount of alimony? Because in other countries like US, if a person does adultery, they have to kind of pay up, or they lose their benefits upon divorce. So why do we have such benevolence or generosity? It's not even correct to call it generosity. It is more like you rob the husband to pay the wife. So other point I have is, the maintenance or alimony amount should be, for the child, should be separately accounted for in the child's own bank account. These days everyone in India has a bank account. I mean, if you want to, there is nobody stopping you. So let the minor child have his or her own bank account, so that there is no misuse of funds by anyone else, including the mother, right? Let's come to maintenance. Now again, just like alimony, there is very perverse kind of legislation and judgments which are coming, which seem to suggest that a woman after marriage has absolutely no responsibility to contribute to family or society, because family anyways she is separated from husband. So kind of you can't force her to live with the husband or take care of anybody whatsoever, and she has no children, but still she is not supposed to, I mean, if you ask of such a wife to work, there are many judgments and comments made by the judges in the courts that that is not it can't be done basically. So this is a very perverse kind of incentives. We cannot have a situation where some people are encouraged to live like parasites upon others. So if a woman says, a wife says, I can't find work, fine, do work at a social NGO, go to some community center, Anganwadi nearby, do some work. Let your talent, let your capability be used by the society. Similar concept is, an able-bodied man is supposed to even drive an auto rickshaw or a rickshaw, or do physical labor to support his wife and child if there is child. There is no similar concept whatsoever for an able-bodied woman. If she is healthy, she has no ailment, no mental problems, but still, it's under Indian laws, she is supposed to sit at home if she wants to, and even from her ex-husband, even after divorce, under CRPC 125, she can claim maintenance for the rest of her life. So that's a very perverse kind of law. Then the other point is interim maintenance. Interim maintenance is kind of injustice, because nowhere else, I believe, in other countries, they will have a case where just because you can't finish a case within quick time, you end up giving relief to somebody, which means that the husband has to pay up with no evidence on record, no cross-examination, no trial whatsoever. So the suggestion is dispose the cases quickly and let the orders be passed only after full trial, right? Coming to child custody, Law Commission has already given a report number 257 in 2015. Let that be implemented, because it has very good suggestions for shared parenting as a norm, making current laws of custody do not have shared parenting or joint custody as a concept at all. They are more like a one person wins and the other person loses, whereas welfare of child is not being a part of these laws. So that is to be taken care of. Remove the word visitation from statutes. Let it be called custody or interim custody. Let there be no visitation. Nobody is a visitor, right? Then I think this is probably one can argue this is not part of the personal laws, but the misuse of POCSO to deny custody is being seen more and more. So currently, because POCSO is considered a very serious, and it is a serious thing, but there is no scope of how to tackle the situation where a father can be put in jail or denied custody for many years, and afterwards he'll be denied custody because child has forgotten you, child doesn't remember you. All those kind of things are used as weapons. Similarly, not to such a kind of serious extent, but pending 490-day or DV case again can't be used as an excuse to deny custody. So there should be a presumption of shared parenting, joint custody, and the suggestion is that let the cases be finished fast. A child custody case cannot be allowed to run for 2, 3, 4, 5, 10 years till the child is 18. A child is losing his time with parents. So let the cases be finished fast, punish false cases and perjury. And I think there is a violation of custody orders. Even after orders are passed, there is absolutely almost zero kind of repercussions if one violates the custody orders. So whatever the laws have to be, overall contempt law has to be changed, or there has to be something put in the custody laws, that has to be done. And this point is something different. This is about POCSO versus age of marriage, because in certain community, even a girl below age of 18 can marry. So I think there was judgment of Punjab and Haryana High Court that they allowed a Muslim girl of I think 15 years of age to marry, whereas Karnataka High Court recently has said that POCSO will override such age of marriage. So this is a very weird kind of absurd kind of situation, that a criminal law can be interpreted differently based on what religion you belong to. So I think that is totally wrong, because age of consent, if you say that age of consent is 18, then how can a person below age 18 consent to marriage or whatever else happens after marriage, right? So that's another point I had. So coming back to this thing, so I think if you see the points here, conflict between personal laws and fundamental rights, making the personal laws gender just. So whatever points we have discussed, most of them are for gender justice. So gender justice doesn't mean justice for women, because that's a general thing that there is patriarchy, all that. But if there was patriarchy, then how do adulterous women, there was a Delhi High Court judgment that occasional adultery doesn't deny a woman right to maintenance. Then there was a judgment of Gujarat High Court recently that even if there is evidence of adultery on the record, but interim maintenance has to be given, because currently it's not a question of evidence. We have to give interim maintenance. Later on we will see the evidence. Now the evidence stage may come after, God knows, 2, 3, 4, 5 years before the trial is over. So gender justice is should be interpreted from men's rights perspective also. Gender is not just women, right? And then there are other points, intercaste, interreligion marriages, best practices, constitution. So that's the same thing we are asking. Constitution means constitution for men. Equality principle has to be applied, and one cannot go in such a to one extreme that constitution means that everything has to be for women or women empowerment. In the name of those, we kind of vitiate the laws and the points that we have covered. So hopefully these points were useful, and people can write their own comments and send the email to the given email ID, and hopefully we will see some change in the laws very soon. So thanks for watching, and